Welcome back to The Explainer. Listen, if you're prepping for the Queensland bar exam, you're going to want to lean in for this one. Today, we are diving into something that's a real game changer, the critical differences between Commonwealth and Queensland evidence law. And trust me, knowing this stuff cold could absolutely be the edge you need.
All right, here's how we're going to break this down. First, we'll set the scene. The two different legal worlds you're dealing with. Then, we're jumping straight into the big battlegrounds, privilege and ID evidence. After that, we'll look at a really tricky area, when good evidence gets thrown out. And we'll wrap it all up with a super useful scorecard, perfect for your final study notes.
And really, this is the question that matters, isn't it? Success on this exam isn't just about knowing the rules. It's about knowing which rule book you're playing from at any given moment, and crucially, knowing where they clash. Because it's in those gaps, those little differences, that exam questions are born.
Okay, let's set the scene. The Queensland bar exam will seriously test your mental flexibility. You've got to be able to jump, and I mean jump seamlessly, between the state's common law system and the Commonwealth's very structured Statutory Evidence Act. You have got to get your head around this one key difference from the get-go. The Commonwealth Act is like a detailed printed street directory. It's a code. It's all written down for you. Queensland law? That's more like a landscape that's been shaped over hundreds of years by judges. It's all about precedent. Two totally different ways of thinking.
First up in our head-to-head, privilege. And folks, this is a huge one. The differences here are stark, they're clear-cut, which, you guessed it, makes them perfect exam fodder. Let's get into it.
So, right away, the Commonwealth Act throws us a small curveball. It takes what we all know as legal professional privilege and rebrands it client legal privilege. But, and this is a big but, don't just think it's a simple name change. Oh no, the differences go way deeper than that. Okay, now this is a fantastic point. On the surface, it looks the same, right? Both systems use the dominant purpose test. But look closer. The source of that rule is completely different. For the Commonwealth, it's spelled out right there in the Act. For Queensland, you have to point to the High Court's decision in ESO. Knowing that distinction, statute versus precedent, is what makes an answer go from good to great. Here is a classic tripwire. Under the Commonwealth Act, Section 127 creates a very specific, very clear privilege for religious confessions. Simple as that. A priest or a minister cannot be forced to get in the witness box and repeat what was said. And then you flip over to the Queensland side, and, well, it's just not there. It doesn't exist, not in a statute, not at common law. Gone. This is one of those beautiful black and white differences that is just an easy mark on an exam if you know it. Okay, what about self-incrimination? The Commonwealth Act has this really clever tool in Section 128. It's called a protective certificate. Basically, a judge can say, look, you have to answer this question, but I'll give you this certificate that means your answer can't be used to prosecute you later. It's a way to get to the truth while still protecting the witness. But under Queensland's common law, it's a whole different ballgame. That right to silence is, you could say, much more absolute here. A judge just doesn't have the power to offer that kind of deal. If a witness claims the privilege, that's generally the end of the line. That certificate workaround simply isn't on the table.
All right, shifting gears. Let's talk about identification evidence. Now, historically, this area was a real mess of complicated common law rules. So what the Commonwealth Act tried to do was take that tangled web and straighten it all out into a nice, clear statutory code.
So what the Commonwealth Act does in these sections is lay down a really clear framework. For starters, it puts the pressure on police to conduct a proper identification parade, because we know that's generally more reliable than just showing someone a single photo. But here's the really crucial part. The Act mandates specific, strong warnings to the jury. The judge has to stand up and explain just how dangerous eyewitness evidence can be, how someone can be 100% certain and 100% wrong. It's all about building in safeguards against miscarriages of justice.
Okay, this next section is absolutely critical. It gets right to the heart of a trial judge's power. What do you do with a piece of evidence that's relevant, but it's just unfairly prejudicial? Or maybe it was obtained illegally? The two regimes could not be more different here.
This is a massive difference. You need to burn this into your brain. Under the Commonwealth Act Section 137, the key word is mandatory. The judge has no choice. If the prejudicial danger outweighs the evidence's value, it is out. End of story. In Queensland, it's discretionary. The judge can exclude it, but they don't have to. It's their call.
And the Commonwealth Act doesn't just say weigh it up. It gives the judge a formula. It's this clear three-step balancing test. You assess the value, you assess the prejudice, then you put them on the scales. If prejudice definitively tips that scale, the evidence is gone. It's a structured process, not just a gut feeling.
And check this out. Section 138 for improperly obtained evidence completely flips the script. In Queensland, under Bunning v. Cross, the judge has a discretion to exclude evidence. But under the Commonwealth Act, it's framed as a discretion to include it. The starting point is that the tainted evidence is out. The party who wants it in has to convince the judge why it should be admitted. It's a huge shift in the burden and perspective.
All right, we have been through the trenches on privilege, prejudice, and everything in between. So let's pull all of this together into one simple, powerful study tool you can take away right now. Here it is. Screenshot this, write it down, do whatever you need to do. This is your cheat sheet. Clergy privilege, yes for COTHA, no for QLD. Protective certificates, yes for COTHA, no for QLD. Prejudicial evidence, it's mandatory exclusion for COTHA, discretionary for QLD. And improperly obtained evidence, the onus is on the tender to include it under the COTHA, while it's a discretion to exclude in QLD. Get these 4 points down and you are well on your way.
So there you have it. You're now so much better equipped to tackle any evidence problem they throw at you. You can see the structure, you know the pressure points, and you get the fundamental differences in philosophy. So the only question left is, what's your next move? Which one of these rules are you going to absolutely master first? Pick one and make it yours.